There's there's a theory going on. Yeah. Same in course 75 as well.
Okay, so what then same drive port. 2, 1, 2. It's going to be much closer to it. Yeah. And it was really sensitive, wasn't it, the other day? Point it would be in outside that is not the correct level. Yeah, that's the one that in the court is fine. Everybody wearing headphones in court will we are fine. But that's through this system. There's two systems. Yeah. Yeah, court comes down is fine. It's the broadcast. I've taken out of the board, trying to take it out, but
I was going to address in particular two questions this morning. The first question about the reason why we say that an enig must apply to the Welsh phrase addas, disc, sy'n addas. And I was wondering whether I could come to that as I deal with the remainder of my submissions on ground 2 in just a moment. And therefore address first of all the question Justice Lewis posed in relation to the redundancy of the phrase an enig. If that's okay.
Yes.
Let me say straight away, we do accept that if the phrase an enig weren't there, then the meaning would effectively be the same. Which would be wrong to suggest otherwise. It does certainly say, to emphasise the point, it could have been made clearer, and I'll take your lordships to other provisions in the Act which show that. But I think the point that my learned friend made was by reference to Fenian, didn't take you there, but perhaps you could turn to that now. It's tab 23 of the Authorities Bundle, section 21.2 of that. It is in turn of pages 511 to 513. I think in the electronic bundle it's page 676. I double checked that this morning. So we see the well-known principle proposition that 21.2, there is a presumption that every word in an enactment is to be given a meaning. But it's clearly not without exception. If your lordship,
Which paragraph precisely in Benyon? 21.2.
21.2. However, under the commentary, under the heading No Sensible Meaning and Surplusage, your lordship see this is on page 512 now. The paragraph which starts, every word cannot be given a meaning. Continue, if there is a deliberate tautology of the words are unnecessary for some other reason, it cites the case himself.
So could you just give me a second?
Of course, my lord.
Just to...
versions have their advantages, but it's
They also have disadvantages, yes. I'm going to just have to rise for a moment.
all right.
Testing. Can you hear me clearly? Is this clear? As clear as it needs to be? Great, thank you very much.
starts at internal page 511. The electronic, I think, 676. Having set out the principle at 21.2, I was taking your lordships to passage under the commentary on page 512, so the next page. Every word, just above this, say potential, but about 2/3 of the way down, every word cannot be given a meaning in terms of deliberate tautology, or if the words are unnecessary for some other reason. Quotation from the Walker Inspector of Taxes against single clothing, often went so far as to say, I seldom think that an argument from redundancy carries great weight, even in a Finance Act. It is not unusual for Parliament to say expressly what the courts would do inferred anyway. And then under the second heading example, it's reference to the Mobile Homes Act, 1993, which states, the owner shall be entitled to terminate the agreement forthwith if, in italics, on the application of the owner, the court is satisfied that it was sought to give a special meaning to the italicized words. Lord Justice Norse, holding that the words must be given their ordinary meaning, said, it is perfectly true that if that is the only function of the words, they could just as well have been omitted. If a long experience of legislative drafting had brought with it a conviction that an Act of Parliament never included words of surplusage, that would no doubt have been a persuasive point, but that is not our experience, and I for one do not complain of it. An emphasis of the obvious, and necessary to a judge who has the benefit of argument, may yet be welcome to a busy practitioner who has not. My submission is that's precisely the position here. The words are not absolutely necessary. That does not mean that they do not carry meaning, and it is the meaning that we contend for. Now, in order to understand the difference of the Welsh text brings, I want to take your lordships first of all to what the appellant says in relation to the English text. This has been a common part of its case, as set out in its skeleton argument for the hearing at the first instance. That's at tab 11 of the core bundle, paragraph 27. That's page 167 of the core bundle. And there you will see the proposition that it does not matter at all for these purposes where the word only is placed within the phrase following the word school, section 52a. The phrase would on any sensible have exactly the same meaning whether it read, and then there are four versions. There's
Paragraph you're adding there.
27. Yeah. It is repeated in the appeal skeleton.
Oh, I see the first sketch.
Yes.
Sorry, which page is that?
167, the core bundle.
167, of course. Sorry. Yeah.
Yes, the phrase would on any sensible have exactly the same meaning whether it read. Then, firstly, only providing education suitable for the requirements of persons above compulsory school age, or two, providing only education suitable to the requirements of persons above compulsory school age. We say that those two things do more or less mean the same thing. Then the third one is, or as in this case, providing education suitable only to the requirements of persons above compulsory school age. And we say that is different. The only there is qualifying something different. Or indeed as C, the claimant contends in respect of the Welsh version, providing education suitable to the requirements of persons above compulsory school age only. That doesn't make sense very much in English. I think it's an attempt to render the word order in the Welsh. But what the appellant said, we understand still says, is in paragraph 29, the above points also dispose of C's case on the Welsh language version of section 52a, since it does not matter where in the relevant phrase the word only comes, it does not matter where an enig appears either. And it's that we say is simply grammatically wrong. In the Welsh language version, which we can turn that up in the authorities bundle, and start in tab 5. We say the corresponding phrase anenig qualifies and can only qualify the clause addysg sy'n addas at anghenion personau sydd dros oedran ysgol gorfodol. That is, education which is only suitable to the needs of persons who are over school age, and that of course is sixth form education. So that's effectively the appellant's version 3 in the original skeleton. Importantly, the Welsh version does not read sy'n darparu yn unig addysg sy'n addas at Cyngor, personau sydd dros oedran ysgol gorfodol. Now that would be the Welsh equivalent of the appellant's versions 1 or 2. It might have read, seems I've had, you can see him on the but that would have the same meaning as what I've just read out. The point we make is that 1 and 2, at least in Welsh, we say in English too, 1 and 2 have a distinctly different meaning from 3. And thus, as a simple matter of interpretation of the wording of the statute in Welsh, if the proposal is to discontinue sixth form education at a school, regardless of whether the proposal has any effect on any other compulsory education at the school, it will fall squarely within section 52A and therefore 51A.
The problem that I've got, I understand that an email qualifies sy'n anghenion, but sy'n anghenion qualifies ysgol. You start off, as I said, with a proposal at anghenion, i sefydlu wneud y rynnu ysgol, and thereafter, everything that comes is explaining which schools are core. So whether you put an email anywhere in the qualification, ultimately, will end up being applied to the thing that the school is providing.
Well, no, because if an ENIG only belongs to the later clause, then if the school provides education which is only suitable for sixth formers, children of a age, it could be a comprehensive school which has a sixth form. Because it would, as well as providing compulsory education, provide education for those of compulsory school age. Perhaps
the problem with that is it really does give no purpose to an ENIG now. Back to your first question. Well, it's much more likely they were trying to explain which schools were core. And although they haven't done it elegantly, what they're trying to get at is a school, wherever you put the word, which does one thing and one thing only, providing education for those above 16.
Certainly in Welsh, it emphasises that if a school provides education for sixth formers, it's covered. That's the heart of the submission that we would do. So that an ENIG does have some sense here. Perhaps if I can take you, your lordships, to why we say that. As a matter of Welsh grammar, it is the position of the words in ENIG, but it's also that they are at the end of and in a separate clause. Sy'n addas at anghenion personau sydd dros ysgol gorfodol, that is important, and not the clause ysgol sy'n darparu. And that's unlike the English version, which of course isn't divided into clauses. The qualification that the adverbial phrase, therefore, an use cannot, as a matter of syntax, apply to ysgol sy'n darparu, a school which provides, and must apply to the later clause. Now, to best explain that, we can look. Because I'd be in this position, but for a Welsh grammar lesson, we can turn to the appendices to our skeleton. I think it will serve best if I take you straight to Appendix 2, which is an extract from an English language version of the modern Welsh comprehensive grammar. I'd ask you to look at the Appendix 2 yours. Yes. Okay, which starts at 464 in the core bundle. And the first section I want to take your lordships to is at page 466, which is under the heading section 144, relative pronouns. And it explains.
I don't have 466 in the core bundle. Oh, wait a minute. Yes, I do. In the one that's there, yes.
Yes, I think it will be the
Modern Welsh Comprehensive Grammar.
that's the the title piece.
Yeah, got it.
The third page then is section 144, relative pronouns. It explains what a relative pronoun is. a paragraph which says, but in Welsh, the paragraph down, there is no real equivalent to the English relative pronoun, and instead the language uses either a special relative form of the verb board, where appropriate, that is see, sometimes shortened to see, sy, with reference to paragraph 229, or proverbial particles to convey the relative sense. You don't need to worry about proverbial particles, but if we turn over to the present relative C, 47, the verb board has in the present tense only a special relative form C or C. This underlying form C, though common in even informal writing, is the less frequent in the modern spoken language, though it will be heard in more careful speech, and in one particular sentence pattern where it appears usually at the end of the sentence. The basic meaning of C in this context is which, who, is or are. It therefore corresponds to my, the first singular board, but with the additional relative element which, that, or who included as part of its meaning. This relative element must be the subject of the verb. And then it gives two examples. Look at the mess which is here. And bring those letters which are on the table. So hopefully with that in mind, the wording in 52A will make more sense. We can see then that the clause is broken, the sentence is broken up. Os ydyn yn y gynigion I sefydlu ysgol. What sort of ysgol? Ysgol sy'n darparu addysg. What sort of addysg? Addysg sy'n addas at anghenion personau sydd dros oedran ysgol gorfodol yn unig. Do not ask me why they've chosen to use both C and C in the same sentence. That is slightly odd. But the words mean the same thing in any event. And then that brings me to the use of only, or only. And that's at page 468, paragraph 435. Dimond in speech, yes, it is, and an unig can mostly be used interchangeably, but their positions in the sentence are different.
Did you say 465?
Page 468. 468. Paragraph, maybe the last page but one.
Yeah.
Paragraph only. Yeah. Dimond, often mond in speech, and an unig can mostly be used interchangeably. Their positions in the sentence are different. Dimond precedes what it modifies, while an unig generally follows. He gives two examples. Dimond, look at the second one, which is an unig. Caniataodd or bobl an unig sydd wedi cyrraedd hyn hyn. Only half a dozen people have arrived so far. And then over the page at the top, it points out that this stresses the thinking you used to make. Dimond cannot modify an inflected word so as to use the inflected preterite that the potential lordship referred to yesterday in the above example would theoretically require an unig. Turn back, the example given is Dimond gofyn nensi, I only asked. But this next sentence, which is important, this in turn is impossible in Welsh because an unig has to immediately follow what it modifies. Here, asked. And therefore it poses the question one would need to say gofynais an unig, I only asked. Gofynais being the short form preterite tense of gofyn. So the rule we say is quite clear, and there is actually little to controvert this. If we...
I understand all of that, Mr. Williams. I understood that some time ago. But isn't it what you said? What proposals are effective? Proposals to close a school. What school? Schools that provide education. Statement of the obvious, that's what schools do. What type of education? Then it isn't meant to be within this qualification.
Well, if it's doing something else, it would be providing, darparu something else, and therefore an unig would have to apply to it if it were to have my learned friends sought after meaning. But provided it does provide education, which is suitable to the needs of the pupils over compulsory school age, logically it will be included. providing that is...
I do understand that. You're saying their suitability, but I suppose I can't get away from the fact that ymwneud would have no meaning. So even though it's in a subclause, seen others, adolygiad subclause, the purpose of this is to tell people what schools are called. And there are a series of descriptions. Schools providing education, a particular type of education, and an ymwneud has got to be given some meaning. So even though it's grammatically inelegant, the Senate must have intended to be trying to narrow down what it was that was covered.
Well, I entirely accept it would be possible to render the same phrase without the phrase any.
Yeah.
I mean, there is proper authorisation to do that.
Yeah.
But I don't accept the word any has no meaning, because it does emphasise the type of education, or the suitability of the type of education, which needs to be provided, but not necessarily exclusively. Because that is what the use of an ymwneud attached to darparu would provide, meaning sixth form college. So an ymwneud simply stresses that if the school provides education to pupils and the suitability of that education is specific for pupils, then it is covered.
But why do they need to stress it? The opening word is Mae'r and this is all about. Anyone reading this, coming to it, knows it's about sixth forms. So why they say this is about sixth form education, and it's education suitable to people above nursery school age, only emphasis. Do the Senate think that people wouldn't understand it?
Well, the answer is that they're stressing it because, of course, on any ground, there is some type of sixth form education which is covered here. But it's not just that which is provided exclusively. It is any school which provides that education. And therefore, it includes sixth form in a comprehensive.
Would you accept or not accept that even if it's grammatically not pure in the way you outlined, it can only qualify seen others, adolygiad, and the rest, it qualifies that grammatically?
Yes, it has.
It has to qualify that grammatically. And even though it's grammatically inelegant, if the choice is between redundancy or grammatical inelegance, it's a matter for the court to try and determine which it was that the Senate was. Was it inelegant or was it verbose?
Well, if it's redundancy, of course, then we're right about the meaning. If it's, I mean, it's not problematic in Welsh. It does have a meaning. It could have been rendered differently. It could have been rendered far more clearly by using one of the methods in Schedule 2 or Section 71, yes.
But that's the question I ask. If it's a question of it having no purpose, the Welsh words in there, or being grammatically inelegant, does...
Well, if one is to give proper meaning to Section 156 of the Government of Wales Act, with respect, it's not open, we say, to someone interpreting this, to simply say that's grammatically inelegant, therefore I'm going to assume that it applies somewhere else to the sentence. Because that won't fit as a matter of grammar. I mean, we say even in English, it's pretty clear. There is an obvious difference between the first two versions of this phrase that we're in frame for us forward and the third. And this has to mean the third grammatically. It might be considered inelegant, but that does not allow one to bend the grammatical rules. It is redundant in the sense that it need not have been there, but it does add some emphasis, and in our submission should be given some meaning. Now, what we've just said is in fact confirmed in the Welsh Government's guidance that we were taken to briefly yesterday. That's tab 27 in the authorities manual. And it's my internal page 17, section 3.8, taking care, placing only. This says take particular care not to this page. Internal page 17, my lord, of tab 27.
Electronic.
729. Which calls for care when using the word only or the Welsh equivalents. Makes the point that it's surely correct. In English, only normally modifies whatever comes immediately after it. It should be placed as close as possible what it modifies. In Welsh, the phrases that include ond normally modify what comes immediately after ond, while an enig normally comes after the word or phrase that it modifies. That confirms precisely the grammatical rule I've just taken lordships to. It says, however, ambiguity may arise because of all these expressions can modify whole phrases as well as single words. But in our case, of course, the ambiguity is solved by the breakup of the clauses. That goes to the C clauses. This guidance, I thought my friend was going to hand it in yesterday. Does
What
exist?
do you mean by the breakup of the clauses?
The fact that whether or not there are commas, the sentence is broken up by each time the word C is used.
You have to explain that. We look at the language in Welsh.
Yes.
You say that a clause is denominated by the use of the word C,
Yes.
or C. So there are two usages of those words.
Yes.
After school
Yes.
and after persona.
After Addis. Yes. It's true that there is a third after persona.
Right, so there's three.
So there are technically 3 C's. Yes.
Why does he qualify dros oedran ysgol then? Fodol.
Well, I mean, theoretically it does, but that amounts to the same thing, because this clause is effectively addas atgenion personae dros oedran ysgol fodol.
Grammatically, I thought you just told us it comes after the last clause, and the last clause is dros oedran ysgol fodol.
Yes,
That's school age.
but that would have no meaning other than the meaning that we contend for. It wouldn't make any difference.
No, it would. If it's above school age only, then
Exactly.
it's the meaning you don't. I mean, what I don't understand is how you can say that this is, well, I mean, I understand how you can say it's broken down into clauses, but it seems to me easier to construe anything. I mean, the thing I find most unhelpful about the judge's judgment are the square brackets in the clause, breaking it down into clauses, because actually, if there are no commas, the thing has to be read as a progression.
Yes, that was intended simply so that the precise meaning of each word could be
Right,
understood.
that's helpful from that point.
Yeah.
Yeah.
It wasn't intended.
But it's not a good construction tool, because the I mean, I can't read the Welsh sufficiently accurately to do it in Welsh, but just doing it in what one might call transliteration. The proposals to establish a school which provides, or proposals to discontinue a school which provides education suitable for over 16s only, is a progression. The which is doesn't disconnect the language. So you can have as many whiches as you like, and we've got 3 of them, but they don't disconnect the language, because you are actually talking about discontinuing a school providing education for over 16s.
Yes. But my lord, the difference of the final C is probably you can take that out and it would make absolutely no difference whatsoever to the sentence.
It hasn't been taken out, so
But it doesn't change the submission that I make, my lord, that an enig applies to the, it must modify what it comes immediately after.
what it comes initially after is dros oedran ysgol fodol, and possibly school age.
Yes.
compulsory school age only. And that's helpful, because if it was people who were below compulsory school age, then it wouldn't be compulsory school age only. Seems, to my mind, the Welsh is actually worse for you than the English.
Well, with respect, no, because if the school is providing education which is suitable to the needs of persons who are over compulsory school age, then that includes a sixth form as part of a comprehensive.
But if I've understood your solutions correctly, help me if you haven't, if I haven't, what you showed us the grammar is the word in ENIC qualify what comes immediately before, and you say that's what comes immediately before, and it clearly marks subclause. What clearly marks the subclause is C from the verb board, or C for the contraction. And the last C we have is before compulsory school age, so it can't qualify ffiniau'r, Canghellor, personae. It qualifies what those personae are. Personae who are dros oed yn ysgol gyfodol, people who are above school age, anemic only. So anemic qualifies the words person, dros oed and onwards.
Yes, I don't run away from that, but the conclusion of the matter is the same.
Yeah, but grammatically, you've been saying for ages, it's ffiniau'r that qualifies, and it isn't, it's Steve Ross.
I do take the last clause to run from C. It actually makes more sense, because over compulsory school age is effectively being used as an adjective.
That's because you're choosing to read that clause as not a true subclause, but as a subset of the previous clause. And the Chancellor was asking, well, if you're doing that first one bit, I think
it does actually read better. But I'm not trying to be inconsistent, and I take your Lordship's point, but all that means is that the conclusion is the same. Does the school provide education which is suitable to people who are only over school age, i.e. sixth formers? If it does, then it's covered. It doesn't actually change anything, but I entirely accept your point. To be precisely consistent, I suspect
what you just said doesn't make your case. If it provides education for people only over school age, in your case, it's not good enough.
No, but I don't say that it says that, because if it does provide education only, would mean that it would be qualifying darparu again. Does it provide education for people?
But let's put the question differently. Let's forget all the subclauses. Schools for which children? Children over 16. This school's got a child of 15 and a child of 14. Is that important? No, because it's not a child over 16.
My Lord, you just they're in the sixth form. I mean, wasn't it? There can be some children.
Oh no, but they aren't there. Yeah. But the point is, it's the school which does certain things, providing education suitable to certain requirements for certain people. Which people? People over compulsory school age. That's what it's getting at.
But it's providing education which is suitable for those people.
Yeah.
And if it does so, it therefore covers the situation.
Which has to be suitable for people over school age only.
Well, sixth form education is suitable for pupils over the age of 16.
Only because if they're 14 or 15, they haven't got to the stage yet where they can understand the 16. If you're 16, you might be doing 15. But if you're 50, unless you're very clever, you wouldn't be doing the 16. I mean, if it qualifies children who are there, if this clause is trying to tell people when you must go and get approval, it's saying it's got to be a school, we're not closing supermarkets, it's got to be a school providing education that's suitable, and who has it got to be suitable for? Only people over 16.
Well, my Lord, no, that is not what that final part of
You know, we're getting round in circles,
yeah.
Mr. Williams, as one does with points of construction. I mean, we have your submission, and I mean, the two new points to me this morning are the Welsh grammar, which I may say I find very helpful, and the three clauses and the three uses of the C, which I also find very helpful. But, I mean, I think we have your submissions, and I'm not sure they'll be improved by a repetition.
be a fair compliment. I do have, for completeness' sake, the Welsh version of these clauses, this guidance. It has the advantage that the examples given are in Welsh. Disadvantage is it chooses to use the word dim ond. But
We'll have that, please. And may I have a soft copy of it?
yes, I think one has been, yes, soft copies have already been made.
Okay, must have gone to my job, but that's fine.
We would say that despite, I was just going to say that the principle is also accepted by the Welsh Language Commission in his written submissions at paragraph 15. And it is probably worth me making quite in passing. The Commissioner set out a number of submissions on the status of the Welsh language text and how it should be interpreted, paragraph 16 to 19 in the submissions, and we would agree with those and suggest that is the best approach to correct interpretation of the legislation. Perhaps if I can turn then to contrast with similar provisions found in elsewhere in Part 3 of the Act. We say that the provision here is to be contrasted with the wording, first of all, of Schedule 2, paragraph 5.2. And again, we can look here at the English version, at the tab 4. This deals with regulated alterations dealing with age range, and says we've set it out in our skeleton. The alteration by a year or more of the highest age of pupils for whom education is normally provided to the school, where the school both before and after the alteration provides education suitable to the requirements of pupils of compulsory school age, and then the words are added, and does not provide full-time education suitable to the requirements of pupils over compulsory school age. Now, if Section 52A were to have the meaning intended for by the Council, then the corollary exclusion should have been inserted and would have been given this. Furthermore, we've already referred to this, the Section 52A is to be contrasted with Section 71(1), which deals with the Welsh Minister's powers of initiating intervention. And there we see, we can look at either 11A or 11C. 11C is probably the more appropriate. The Welsh Ministers may make proposals under this section for the discontinuance of one or more maintained schools which provide secondary education suitable to the requirements of sixth formers and no other secondary education. Again, a similar phrase could and we say would have been used if Section 52A was going to be interpreted in the way the Council intends for. If the Council's right, of course, it means that Section 52A effectively applies to sixth form colleges, and we say that would seriously undermine the additional protection which the Act and indeed the Code gives to schools which provide sixth form education when a proposer is considering to discontinue that education. The reason for that, well, this doesn't really seem to be contested now, is that such additional protection is found in the way in which post-16 education is funded in Wales, and there is a description of that, my lord, in the supplementary bundle. If you're to pay for the reference, tab 18, page 317. So it's tab 18, 317. It's in the exhibit to the statement of Catherine Lyles, and it probably suffices to read the overview on page 319. certainly the first sentence, which reads, funding for further education institutions, FEIs, and school sixth forms are funded in different ways. It doesn't say sixth form colleges. And that was a... Well, so what we say is that the judge's interpretation of the section was entirely consistent with the Welsh Minister's direct responsibility for securing education because above school age, pursuant to section 71, as he found in paragraph 82 of his judgment. And in closing on this ground, my Lord, just this one final submission. It's common ground that closures of sixth form colleges, at least, are covered by section 52A. It's also clear the situation that closure of sixth form alone, where the remainder of the school continues, is covered by section 52B of Schedule 2, paragraph 6.2. If Welsh Minister funded sixth forms are not to be protected in these circumstances, are to be protected in those circumstances, what are the logic for them not to be protected when there is enclosure of an entire school, both pre and post 16 pupils, especially when pre-16 education is to be retained by the opening up of a new school, perhaps even on the same or adjacent site, but with a slightly altered age range to use the sixth form. It really doesn't make any sense. Well, also, I'm going to turn now to grounds 3 to 5 of the appeal. You've been taken to the code, the Welsh Government School Organisational Code. In our skeleton, we refer to one of the first judgments on that. It was the case of McCann. What we've set out in our skeleton, two passages. I'd like to refer to the second. This is paragraph 44 of our skeleton. Because my learned friends pointed out the difference between where there were mandatory rules in the guide and where there was requirements and there was guidance to be followed. And in McCann, the court went on to consider circumstances in which a local authority, having regard to the guidelines, and you'll be aware, of course, that paragraph 1.9 contains such guidelines, should provisions in the code when they may depart from them. It was said, a person to whom the code is addressed is under a duty to have regard to the guidelines it contains, but is not under a duty to follow them. However, unless the careful interrelationship of the instructions and guidelines and the significant role given in the code to the latter are to be undermined, it is necessary that the decision maker who departs from the guidelines in a material way should have a proper reason for doing so. Should state that reason. The judge, for instance, referred to that. Now, we maintain that the council breached the provisions of the code and it took its decision on the 18th of July. And it certainly failed to give proper reasons for departing from the guidelines in particular. The principal breach is of paragraph 1.9. That's always been our case. There was an ancillary breach in relation to paragraph 1.4.
1.9, the case that is put against you, in short, is this. The judge forgot to look or didn't mention the heading. And the heading says, specific factors to take into account proposals to reorganise secondary schools or to add or remove sixth form. And the proposal 4 is not to reorganise secondary schools or to add or remove sixth form, is to close on sound primary schools. That's what's put against you.
Yes, that's ground 3.
Yeah.
Before I address that directly, I did just want to say how the claimant did put it to her case. We were given leave on the 3rd of April to amend the statement of facts and grounds to include the ground that your lordship has just referred to. We say it's clear from that it was predicated on the following matters. Firstly, that the effect of the proposals on the provision of Welsh medium education in the Pontypridd area, as set out in the evidence that was filed in support of the original claim, going back to October 2019, and a particular note were the statements which detailed the likely loss of learners to the Welsh education system as a result of the proposals. Secondly was the proposed findings of the investigation of the Welsh Language Commissioner, which confirmed that in respect of the consultation, there had been a failure of the Council to comply with the relevant standards, 1993, which we said were relevant to the obligation set out in paragraph 1.9. And thirdly, that the Council's breach of its duties under the Code, but that it failed to take into account the specific factor of proposals to reorganise secondary schools or remove sixth forms, namely, how the proposals might affect the sustainability or enhancement of Welsh media provision in the original Ordinance 19 network, which we say clearly is a breach of paragraph 1.9. Now, in the detailed grounds of resistance in response, which obviously came afterwards, we learned yesterday the 20th of April, I think, so at the same time as the first tranche of the Council's evidence, the Council stated that its obligations under the Code, so far as the Welsh language were concerned, were found in paragraph 1.4. That's the detailed grounds of resistance, which are in the core bundle. Core bundle at tab 9, page 93. Referring to paragraph 4.2.3. So, in relation to this ground, the Code recommends in paragraph 1.4 that local authorities should publish a Welsh language impact assessment where proposals affect schools in which Welsh is a medium of instruction. This is what the Council did, therefore there was no failure to follow the Code. It says the provisional finding of the Welsh Language Commissioner draft report about compliance do not assist the claims. The Council was not proposing any changes to Welsh Medium Secondary Provision, but instead to Welsh Medium Primary Provision. Welsh Medium Secondary Provision was considered when developing proposals as part of the Council's consideration of its Welsh in Education Strategic Plan. Now, we found further witness evidence which referred to the likely loss of learners to the Welsh system as a result of the proposals. Principally through the statement of Catherine Lyons on the 4th of May. And she also responded to the detailed grounds of resistance and set out the respondent's criticism of the Welsh language impact assessment. You'll see that in the supplementary bundle at tab 18, pages 311 to 314. And important in this, in our submission, is what she says at paragraph 93, where she takes up what the Council had said in its own detailed grounds of resistance at paragraph 72. The Council's eventual preferred proposals did not entail a reorganisation of Welsh medium provision for those aged between 14 and 19. The Council did not consider what impact those preferred proposals would have upon Welsh medium provision for those aged between 14 and 19, because to do so would have been pointless. The proposals clearly had no relevant impact, because they concern English medium provision only. She then goes on to criticise that statement, but the point is that the Council's defence was the provisions were not engaged at all. No, we didn't consider this, but we didn't need to. And it's in the light of that in our submission that one needs to look at the third ground of appeal.
Well, is that strictly fair, given the second statement in paragraph 28?
Well, my Lord, my Lady, the Council did try to row back from that, but it's a pleaded case.
Well, you say row back. She made a statement that may strike some of us as being common sense, which is that there is recognition that changes to Welsh medium primary education can have an impact on the take of the Welsh medium secondary education.
Lady, absolutely. That was an admission, if that's what it was, that both the claimant and the court latched on to, accepting the inevitable, that in fact, simply because the proposals didn't concern Welsh medium secondary education, did not mean that secondary education wasn't going to be implicated, and therefore that the provision in the code was not applicable. But what the concession was in the detailed grounds was that it may have been their case then that it was pointless, but that they had not considered this impact.
I'm sorry, my lady, that was not our case. I mean, we said we had considered the impact, but the point that we are making was that we, in respect of the English medium proposals only, that is to say, the proposals which concerns reorganisation of forms, proposals 1, 2 and 3, the impact being considered at an earlier stage when we were deciding should we reorganise English medium education, Welsh medium secondary education, and we accepted that the council had not gone back in respect of those proposals at the determination stage and said, and now let us look, having decided to proceed with these proposals only in respect of English medium education, at how they might affect sustainability of Welsh medium education in the future.
Well, perhaps I was wrong simply to refer to this by cross-referencing the statement, but at page 109 in the core bundle, at tab 9, there is the council's stated case. In relation to what Lisa Howells then said in her further statement, the claimant had various criticisms. There, all of a sudden, we had to look at, notably, the Welsh language impact assessment, which is where one would have thought that one should look. But it was woefully inadequate in dealing with this issue. It didn't deal with it at all. And those were the submissions that we made, and those are the submissions the judge accepted, as I shall come to in a moment. What I want to do is to make good the case for Lisa Howells' common sense, one might say, acceptance, that there was a link here. The council says that the court erred in its interpretation of paragraph 1.9 because it relates to sixth form proposals and is not concerned with proposals to reorganise primary schools. In fact, in the grounds there was little, and the skeleton argument, little more advanced than to say that. And we simply adopt the position that we set out at trial, which was in our original skeleton, and accepted by the judge, for instance, at paragraph 101 and onwards. That's at tab 7 in the core bundle. Pages 69 to 76. And in summary, the four proposals were intended to reorganise or had the effect of reorganising secondary schools and removing sixth forms. There were changes to Welsh medium primary education in proposal 4. They inevitably impacted upon the take-up of Welsh medium secondary education. Any proposals, therefore, to change Welsh medium primary education should have considered how that might have affected the sustainability or enhancement of the Welsh medium secondary provision in the 14 to 19 network and access to post-16 Welsh medium courses. Now, it is undoubtedly the position that the council's proposal were intended to provide a large-scale reorganisation of education in the Canterbury area. The interconnected proposals included the reorganisation of secondary schools and the removal of sixth forms, together with the changes to Welsh medium primary education. The council accepted, and I think still accepts, that the proposals are interconnected. A little bit going back on that yesterday. And there were various references in the bundle before the court at first instance. But the council's skeleton argument does seem to accept that even now at paragraph paragraphs 1 and 53. That's the core bundle, paragraph 23. Pages 282. Well, starts at 281. Talks about its decision to proceed with 4 interconnected proposals comprising a large-scale reorganisation of schools in the Greater Canghellor area. And then 296, paragraph 53, where it is said, it's in a footnote actually, at the end of paragraph 53, under the 4th of its interconnected proposals. And that is precisely what the judge found. 3 paragraphs in his judgment, 789 and 50 and 150. This again is tab 7 of the core bundle. Page 46. Where he said at the beginning of paragraph 7, the proposals are all interlinked, use that expression rather than interconnected, at 89, which is on page 66. The parties each explained, although in different terms to one another, the proposals were all interlinked. And then again at paragraph 150 on page 80. So in our submission there really can be no dispute about that.
Okay, hold on a moment. They are legally 4 separate proposals, aren't they? As a matter of section 48. Each one is a separate legal.
Each one has a separate notice.
Yeah. And there are separate legal proposals. You can decide to implement one and not the other. They're interlinked in the sense that it's coming out of the whole of point of view. So is your case, you've got to deal with a heading 1.9 at some stage. And you say proposing to reorganise secondary schools or to add or remove such forms, all proposals connected or linked to those, is it? Page 29 of 350. That's the case again.
So your lordship's referring to the heading in the code?
Yes, but that's a specific factor to take into account when the proposals to reorganise secondaries or to add or remove sixth form. Proposal 4 does not of itself fall within that.
Not proposal 4, but proposals 1, 2, and 3.
Yes, but you're not complaining about those.
Well, they are for other reasons, but what you say is all 4 proposals were interlinked. I mean, for instance, in relation to 2 and 3, they involved not only the closure of the secondary school sixth form, but also the closure of the entire school and the reciting, the reopening of new junior schools, and the reciting of one of the schools, as we've heard, on the site of the Uchel school, the new Welsh medium schools.
And just not with you, I'm sorry to be slow, Mr. Williams. If we take proposal 4 and we forgot for a moment about 1, 2, and 3, would proposal 4 fall into 1.9 or would it not fall into 1.9? The heading.
Proposal 4 had been advanced on its own.
Yeah.
There had been no other proposal, then it would not.
So it's because it's linked to proposals 1, 2, and 3?
Yes. But that it was linked.
Hold on, so it's on its own. Not because linked to proposals 1 to 3. If it falls within it.
Yes. If it is clearly the case the council would not have simply proceeded with proposal 4. It was so interlinked with 2 and 3. If there had been no other proposal than proposal 4, and obviously whilst paragraph 1.9 would on its face not have been applicable, and there were proposals to reorganise sixth form education, that would have meant, of course, no less that there would have been an effect on Welsh medium secondary education for the reasons that Mr. Howard and others have accepted. And one then presumably would have been looking more closely at paragraph 1.4, which of course applies in all cases. and the sub-paragraph under the second bullet point, which reads, in all cases, existing pupils at a school where provision is being reduced or removed must be able to continue receiving education that provides at least equivalent standards, and opportunities for progression in their current language medium. Specific transition arrangements may be necessary in order to achieve this. But given that that wasn't the case, we were facing four proposals which were interlinked, interconnected, however you want to put it. We say paragraph 1.9 was engaged, and therefore that was the gravamen of the attack.
I'm sorry, this wasn't the case that was run against us at trial, and I do have a fundamental difficulty with a case that would demand new factual investigation, in this case, of the necessary links between Proposal 4 and Proposals 1, 2 and 3, and whether one could continue without the other, now being advanced on appeal. At trial, this was put forward squarely as a breach of paragraph 1.9 by reference to Proposal 4. See my learned friend Skeleton.
Oh, that's precisely what I've just said. And although I didn't take a lot to the provisions in our skeleton trial, I simply summarised them. That was the case that we put. There were four interlinked proposals. Paragraph 1.9 was engaged, and the council did, because of the obvious knock-on effect of reorganisation of Welsh meetings, the primary schools, and didn't to consider the impact on the 14 to 19 year old.
Well, I suppose the best point is that proposal 3, if I've got the facts right, the English medium pupils at Kelly will go to the new Orffennaf school, and the Welsh medium ones will go to the new Rhondda Cynon one. But you point Sean, you call it, not Cynon.
Well, I believe there's somebody called Sean Norton.
Like it's not Cynon the chapel, it doesn't matter. Sean, the point is that the English language pupils at Kelly will go to a new school. So you couldn't implement Proposal 4, you say, on its own. If you close Kelly Primary School and opened new Welsh language primary school, where are you going to put the English one?
This is presumably why the council agreed that these were.
That's your point on the fact.
Yes. Now we say it was uncontroversial that the retention of children in the Welsh medium secondary education was dependent upon the availability of Welsh medium primary education. It almost went without saying. And therefore, of course, the continuation or transition from primary school to secondary school. It was never formally conceded by the council, but it's already referred to that the council did accept within its own witness evidence, that's the second witness statement of Lisa Howell, paragraph 28, that changes to Welsh medium primary education can have an impact on the take-up of Welsh medium secondary education. And the judge commented on that and accepted that as paragraph 114 of the judgment. So the respondent's case then was the proposals involving the changes to the primary education should consider how the changes might affect the sustainability and enhancement of Welsh medium secondary education. And the court accepted that logic at paragraph 115 of the judgment. That's tabs, core bundle, tab 7, page 72. He expressly accepted the submission, and we say he was right to do so. But also, I've just been reminded of the paragraph in our initial skeleton which sets out these points. It's in the core bundle on page 150. So lest there be any doubt as to what we were saying at trial. Paragraph 121. Our case on this, the knock-on effect, was supported by statements from several witnesses who gave evidence as the use of children from the Welsh education system should the proposal succeed. Now, the judge summed those up as saying that pupils who do not attend Welsh medium education are lost forever. The evidence in his judgment of paragraph 114. Our case was also further supported by an email from the Welsh Government to the defendant on the 23rd of January, which highlighted the absence of information regarding the extent to which the proposals contributed to the 14 to 19 agenda. That I'll just give you the reference is in the supplementary bundle, tab 15 on page 278. So, in the light of the Council's approach to its obligations under the Code, simply that it had to produce a Welsh language impact assessment, our case was that the consultation document was lacking, and the respondent made several points in evidence in respect of the appellant's balance sheet analysis that was found in the Welsh language impact assessment. We also looked at the community impact assessment and the quality impact assessment. Those are the arguments set out in our original skeleton at paragraph 113. We maintained throughout that the Council had failed to assess the impact of the proposals on the Welsh language in any meaningful way. And those are the submissions that were accepted by the judge at paragraph 119 in his judgment. That's at page 73, tab 7 in the core bundle. Where he described it, the Council also relies on the Welsh language impact assessment as well as the community impact assessment and quality impact assessment. That would then in support of its assertion that it considered how its proposal might affect Welsh medium education. The Welsh language impact assessment document, however, even though it was updated, was of extraordinarily limited content in terms of the impact upon the Welsh language of the proposal. And he goes on to say, 5 lines further down, nor does the Welsh language impact assessment strike one as considering the sustainability or enhancement of the Welsh medium provision, as stated in paragraph 1.9 of the Code. It says that the assessment contains a large amount of bald assertion, and a large amount of it concentrates on transport issues. I would estimate that in approximate terms, only about 10% at the most of this document even considers the impact of the use of the Welsh language at all, let alone how the proposal would affect the sustainability or enhancement of Welsh medium education. The document recites a commitment to the Welsh Government Cymraeg 2050 target, that more is required in the paragraph 1.9 of the Code than a simple recitation of this. I also accept the claimant's criticism that the impact assessment fails to assess the impact of closing Montreal Norton on the Kilfynydd, Glyncor, Coedwicwm or Ynysybal communities moving forward. It also fails to consider the point I've already mentioned, namely how the changes to Welsh medium primary education would or may affect Welsh medium secondary education. In my judgment, the inadequate content of the Welsh language impact assessment demonstrates that the Council failed in its duties in this respect. There is nothing either in the quality impact assessment or community impact assessment that makes good this deficiency. Now, the Council continues to maintain that paragraph 1.9 was not engaged because its proposals did not entail a reorganisation of Welsh medium provision for those aged between 14 and 19. And we simply say that that assertion is wrong for the reasons that we've given. And the acceptance that they failed to comply, did not comply, because they say it was not applicable with paragraph 1.9, sits very awkwardly with the assertion now that, and they actually did if one looks in detail at this documentation. The judge analysed it in great depth and came, we say, to the right conclusion on the evidence that one could not possibly say that there was compliance with paragraph 1.9 on the basis of the documentation he'd been given, despite the bold assertions made.
But can you explain why that is? Because, as I understand it, and you'll tell me if I've misunderstood it, what is said is that there are 3 ways in which this could affect people choosing Welsh primary schools in the future. One, existing pupils might drop out, answer is guaranteed that the existing ones can go. The second is, will there be enough places for projected demand? And they say we've got 93 extra places. The third thing would be if people were deterred from going to Montreal Norton because it's too far away, they might opt for an easier drive or walk to an English medium school, and those would be the lost learners. And what Mr. Milford says is if you look at the information in the document, that's why there was the emphasis on transport. They've considered and taken the view that there will be no lost learners. So if they've done that, is there anything else about the impact on Welsh medium secondary education going forward that has been taken into account?
Well, there was specific evidence that there would be lost learners, principally for the third reason, the additional transport, and the fact that all that follows on from having to take transport to school, notably after school activities.
Yeah, well, they say in their documents it covers that, but the judge wasn't really impressed by the evidence of individuals. He didn't take paragraph 120. Yes. So what's your response to the fact that there are 3 ways in which, in reality, changes at the primary school level will affect secondary level, and each of those has been addressed, they say?
The judge's conclusion, which we say was right, was that the mere assertion that that had been taken into account was not sufficient. I mean, there wasn't any analysis that what the effect would be of the proposals on the Welsh medium education in the 14 to 19 network. That of course, is well advanced into secondary school. We've got the 11, 12, and 13-year-olds first of all. There was evidence, and he accepted the general principle that there would be pupils lost by virtue of these proposals, and there was simply no detailed analysis of what would happen. Simply to say there will be school transport, in my submission, it was not looking for the judge rightly found. Simply to say, well, there will be enough spaces. Again, spaces is different. People may not take them up. Exactly. And this was a point that the Welsh Language Commission made quite strongly in relation to the location of schools and how the parents regarded the local school as important for a variety of reasons, just the amount of time that it took to transport their children there. And my assumption there was ample paucity in the evidence for him to come to those conclusions. And perhaps the judge was rightly fortified by the idea that the council had come late to the table, perhaps had better addressed this issue, and was searching in documents for any reference to the Welsh language at all. So certainly we say there was nothing wrong or illogical in the findings that the judge made in those respects. I'll turn now to ground 4, which is that the judge was wrong to find the appellant had breached paragraph 1.4 of the School of Organization Code. I've set out what the principal case of the respondent was. The appellant now says that we didn't allege there was a breach of paragraph 1.4 of the code, that the defendant had no opportunity to address that question, and that the findings were manifestly contrary to the evidence. We say each of those is without foundation. As we've already seen, it was in the detailed grounds of response that paragraph 4 was specifically cited by the council as being effectively its only duty in relation to the Welsh language. That's what its case was, paragraph 4.2.3, I took the worships to. And it said it had complied with that by merely producing the Welsh language impact assessment. We responded to the reliance on the Welsh language impact assessment in the context of the assertion that there had been a breach of paragraph 1.9 of the code, because the respondent said it was so woefully inadequate in this regard, and hence the evidence was filed by Catherine Lyles to that effect. There was evidence filed, as we've heard from Lisa Howells, which purported to explain the decision and how it had complied with its Welsh language duties. But it's, in the light of all that, it's clearly not right to say that the Council did not have the proper opportunity of addressing the issue of whether paragraph 1.4 had been breached. Quite some time was spent dealing with that issue. Though I accept, always in the context of paragraph 1.9, because that was the respondent's principal claim. And we say that the court was therefore within its right to make findings on the sufficiency of the consultation document, most notably, but also the Welsh Language Impact Assessment, for the purpose of establishing that there was a breach of paragraph 1.9. And having made those findings, the court was perfectly entitled to make the further extension that the defendant was also in breach of 1.4 on the same facts. In any event, the formal finding of breach of paragraph 1.4 didn't affect the basis for the proven breach of 1.9. As I've said, it was the claimant's case. If there was any suspicion of procedural irregularity, this matter ought to have been raised with the Church at the time. And our submission is too late to do so now. Round 5 then is that the court urging finding that the appellant failed to consider how his proposals for Welsh medium primary education would impact on Welsh medium secondary education. To a large extent, this is a rehash of matters that I've already dealt with. Of course, it is the case that it would not normally be the case that evidence of Miss Howell, as such, would be subject to cross-examination and judicial review. But that does not mean, merely because she wasn't cross-examined, that the court was obliged to accept the evidence in the witness statement as if it was unopposed. It was contested. A lot of Catherine Lyle's criticisms of our evidence are quite cogent.
Obviously, a basis in judicial review, if you're not going, if a witness from a public body with a statement of truth says, I consider this, there then needs to be a basis for saying, no, you didn't. And that could be contemporaneous documents, which is what is usually the case, or rarely, but occasionally, cross-examination.
Yes, the contemporaneous documents did not support what she was saying.
So the contemporaneous documents show that she was likely mistaken in her belief that she considered it adequate.
Yes, a spin was put on what had been produced at the time to try and meet the claimant's case. We say well, the function of the court in respect of ground 2G, that's what original claim was to review whether by reference to the relevant documentation, obviously includes the witness statements, but the other documentation too, to see whether the defendants have failed to take into account how the proposals might affect Welsh medium education under paragraph 1.9. And the council seems to be submitting now that the court have accepted Miss Howell's bold assertion. The council did consider all these matters. Firstly, it suggested it was illogical for the court to suggest that its defence that it decided not to reorganise Welsh medium secondary education showed that it did not recognise the link between proposal 4 and Welsh medium secondary education. But the judge gave a clear and logical rationale on that in his judgment of paragraph 116. He says, there are two, this is third line in paragraph 116, page 73 of the core bundle. There are two difficulties with this line of defence by the council. Firstly, it wholly ignores that there is an obvious link, and one which is essentially accepted by Miss Howell's evidence, between proposal 4 and the impact that will have on Welsh medium secondary education. Secondly, it demonstrates that whatever Miss Howell states in her evidence now about the acceptance of the link between Welsh medium primary education and Welsh medium secondary education, it was not something the council realised or acted in accordance with at the time. The council decided that there was to be no reorganisation of Welsh medium secondary education, and so that was the end of any consideration about the impact of any proposals upon Welsh medium secondary education. Those involved failed to address how the reorganisation of Welsh medium primary medium education would impact upon Welsh medium secondary education. And they failed, in my judgment, to consider how the decisions that they were making either contributed to the strategic aims of increasing the use of Welsh and or whether they were treating Welsh no less favourably than English. I would go further and say that the council failed entirely to consider how reorganisation would impact upon Welsh medium secondary education. Council is critical of the Court's observations in relation to the consultation document, paragraphs 170 and 180 of the judgment. We maintained that there was no consideration within that document of the impact of the proposals upon the sustainability for the purposes of paragraph 1.9. And the absence of such consideration within that document, in conjunction with the absence in any other documents, presented a logical basis, we say, for rejecting Ms. House's evidence, including that this was not a factor that had been properly considered. And while much can be said about what the Council says the Court was wrong in relation to the Welsh language impact assessment and the Court's judgment at 119. Again, we maintained that there was no consideration within that document of the impact of the proposals upon the sustainability or enhancement of Welsh media provisioning in the local 14 to 19 network, and again, in the absence of consideration, that presented a logical basis for rejecting Ms. House's all assertions. And therefore that criticism cannot be maintained either. My Lord, those are my submissions in relation to the grounds. I think perhaps I should say something about the issues raised about Welsh-speaking judges. I'll be very brief on this. We saw the sense in that too. We made an application. It was made as soon as it was reasonably obvious that reference to the Welsh language, Welsh version of the legislation was going to be made. It wasn't just before the hearing, but anyway, it was rejected, and we understood that. In the circumstances, we think that the learned trial judge did his absolute best, and in fact, whatever one considers about the outcome, produced a paradigm example of how a judge should, if he is not Welsh-speaking, analyse the Welsh-speaking legislation with the assistance of counsel and the parties. That is why the literal translation was produced. It wasn't to, in any way, convey that the English language text wasn't valid, but it was to show precisely the syntax and makeup of the Welsh sentences, so that you could begin to understand the submissions that were made on behalf of the claimants. It has to be said that if this court could give any guidance on how future courts should deal with this matter by way of listing first instance, that would be very helpful. These matters arise rarely. I mean, first of all, there has to be a discrepancy in the legislation, or a purported alleged discrepancy in the legislation, or possibly guidance. I suppose that, to my knowledge, this issue has only arisen twice ever. It also needs to be pertinent, of course, to the case in question, and point needs to be taken, which means that the lawyers need to, and therefore, yes, it would be helpful possibly if, when seeking directions, this point was made. But it would be wrong in our submission simply to say that in all cases it is not necessary that the Welsh-speaking judge should deal with those situations. And we certainly do support what is said by the Welsh Language Commission, and I think the Welsh ministers too, in relation to other means. One cannot involve interpreters or other assistants. It is a matter for the judge himself, unfortunately. Yeah, may I just check that I have the rule once? Thank you very much. Those are our submissions.
Thank you very much, Mr. Williams. Just before Mr. James begins, and I think Mr. James is going to make his submissions in Welsh, and we'll make use of these, which I think switched on, but I just say that, Mr. Milford, we're going to try and finish this case before lunch. Yes. Even if that involves sitting till 1:30. So then just ahead and warn you that when Mr. James is finished, we'd like to hear him reply.
I shall consider myself warm. And I hope to be less than half an hour in reply.
Yes. help me turn this on.
My lord, if you just open the headphones, they should automatically switch on. You should be able to do it. It's exactly correct.
Yes.
Thank you very much indeed.
Yes, Mr. James.
Firstly, I would like to deal with matters arising in terms of principle and framework, bases and grounds 1 and 2. The Welsh Language Commissioner does not contest any particular meaning, so is neutral in terms of the interpretation of section 50 of the Act. But as the other parties have stated, this case is considered to be important and appropriate for providing guidance to lower courts as to how to deal with the statute bilingually. Following that, briefly I will deal with matters arising in relation to grounds 4 and 5, mainly 5, and that is the code within the context of the Council's duties in relation to consulting on the Welsh language more broadly. Even though it is a narrow question that arises on the basis of grounds 1 and 2, as in to what purpose are the words only included in section 50, the matters of principle are very important and broad. And because of that, the Welsh Language Commissioner has intervened on grounds 1 and 2, even though he did not do so before the High Court. Because there is a body of law devolved, which comes before the courts and tribunals of Wales and the courts of England and Wales, it is not a specific element before the Court of Appeal. That's not the subject of the text. It's not about understanding the word alone that's important, but understanding it in order to be able to understand the meaning of the Act in its entirety, i.e. both Welsh and English. And so therefore, the Welsh text should not be seen as a marginal issue or an exercise in ticking a box, but it is an integral part of the interpretation of the meaning. On that note, section 156 of the Government of Wales Act states that the Welsh and English texts, and in that particular act is only in English, that they are of equal standing. The same term of equal standing is included in the Welsh Language Wales Measure 2011, and the usage of Welsh is given as a status quo equal standing, so both languages are treated on the basis of equality or on a practical level, that they are provided with equality and equally. In terms of any assistance provided by this court, I note that Part 5 of the Legislation Wales Act 2019, in terms which may be a little different, i.e. the Welsh text and English text have equal status for all purposes. That is stated there. In my recommendation, there is no relevant difference between those two provisions, and so any assistance provided by the Court of Appeal in this case will be applicable for legislation dealt with by the Government of Wales Act and the legislation measure. It's worth noting that the language of the text is what is important and not the language used before the court. And even though there is a relationship between those two things, both are different. The Welsh Language Commissioner is grateful that permission was granted by the Court of Appeal when it was sitting in London for the submissions to be made through the medium of Welsh, because there was a need for permission at that time. But in any case, the Court of Appeal they would have to look at the Welsh text, even if neither party made any recommendations or submissions to the medium of Welsh. And of course, without the intervention of Welsh ministers and the intervention of the Welsh Language Commissioner, the argument before the court would have been solely in English in the High Court and indeed before the Court of Appeal.
Question am arferol. Mr. James, whether, as you say, that in every case where the meaning of a statute that is in both English and Welsh is in issue, it's necessary to consider both versions? Or would it be open to the court at any stage to, if there was no suggestion by either party that anything was added by looking at the other version, can the court just look at the Welsh version or just look at the English version, since they are of equal status?
One can adopt one text to facilitate the process before the court, but in doing so, a higher status should not be afforded to the text which is being used. At a practical level, therefore, if there is no difference between the two texts, as the court, in hearing a submission solely in English or in Welsh, then usually it would deal with the legal text in one language. Practically, that makes sense, but that should not be taken to mean that there's an acceptance that the solution lies solely, or that the meaning of the legislation comes solely from that particular text alone.
I'm getting at is that if the court looks at one language because the argument is taking place in one language, and neither party before the court suggests that the other language has any different meaning, then presumably it is safe for the court itself not to look at the other language in construing the statute.
We have to accept that if there is no submission before the court which deals with the other text, then it's very difficult for the court to deal with that text in whichever language. The argument, of course, is because the meaning of the legislation is to be taken from both languages, and the function of the court is to interpret the meaning of the legislation, not narrower in the meaning of the legislation in the language before the court. There is a possibility that there is a need. At a practical level, the question before the court is the question of interpretation. And by necessity, therefore, if the court is not willing to deal with the English text in the way as the Welsh text is intended to be dealt with, then by necessity the two texts are not being dealt with equally, and therefore that's the prism in my submission through which the different methods of reaching the meaning of the legislation should be reached. The stance of the parties before my lords is the same narrow point that I want to deal with, is the stance of Welsh ministers who are limited to the situation before the High Court and not before the Court of Appeal. Quite simply, the Commissioner notes that the argument about the ability to understand the law through the medium of Welsh before the Court of Appeal in my submission is stronger. As a court, a higher recording court, it's more important that the text bilingually should be understood and understood fully before the Court of Appeal than before there is a possibility also that there are matters for the Senedd or the Westminster government to consider, the Westminster Parliament to consider, or the Civil Procedure Rules Committee. It is a matter of the rules and changes to facilitate any support or assistance that the Court of Appeal selects to provide in this case is what is needed, not changes to enable the function of interpretation to take place. The important principles included in my submissions are accepted by the claimant. Briefly in my submission, that's the framework that should be used. And the most difficult point is the point that arises that the principles of statutory interpretation apply to the consideration of the Welsh text. English text should be used in the Welsh text. That's the narrow point that creates or can create problems or practical problems. There is a possibility of using other methods, such as translation or expert evidence, but in my submission, they should not be considered as a positive step, but rather as actions which try to mitigate against shortcomings which by necessity arise without there being a Welsh-speaking court judge. The Law Commissioners looked into these options, and Welsh Ministers and the Welsh Language Commissioner have made use of and have provided a copy of the Law Commission report, and on that report, for the most part, that's what my written submission is based on for the most part. I'll deal briefly with some of those matters. Firstly, the question of using simultaneous interpretation. In a case, as now, where a party wishes to use the Welsh language and the court is not able to speak Welsh, then using interpreters enables the court to understand what is being said. Simultaneous interpretation is what it is, not translation. It's a different role to a legislative translator and a very different role for providing expert evidence. So those questions arise mostly before the Immigration Tribunal, where there is a need for clear differentiation between the role of experts and the role of interpreters. And that is something which has been determined and is something which is very important in my submission, certainly in terms of the interpretation of the legislation, but also in terms of translating documents in the face of the court. It's very different to translating documents, and that translation being agreed between the parties and included in the papers. There's a need to differentiate between the role of the interpreter and any role in evidence or communicating legislative information. Those options of expert evidence or translation interpretation are matters that are necessary in my submission, and that they mean that the function of interpretation of the court.
Yesterday and today is slightly different, because we made poor Mr. Williams take us through ad nauseum the Welsh. So there wasn't a translation, we didn't have an agreed text, we didn't, as it happened, use the interpreters. Was there anything undesirable about Mr. Williams taking each of the three of us through the Welsh? We didn't even look at the English, oddly enough. We only went through the Welsh.
But that was
Cymraeg. Y Comisiynydd bod angen barnwr sy'n medru'r Gymraeg. Gellir Gymru i feddwl hyn. Yn gyntaf, bod angen barnwr sydd yn gyfforddus i fod yn ddeall ystyr y geiriau statudol sydd ger ei bron yn yr achos hynny. Yn ail, ei fod e'n mynd i'r deall ffurf y gystrawen ac unrhyw effaith
tax and the meaning of the legislation. And thirdly, that they are able to reach to the interpretation independently in Welsh or in English. And then finally, without commitment, without prejudice, to the language of the submissions, then the Welsh text and the English text should be treated equally. So as a result of that, in order to deal with the interpretation of legislative text, it is not necessary to have a judge that can speak Welsh and is able to hold a case, a full case, but rather the ability to use and interpret the text before them. Now in this case, it's a fairly narrow text. In other cases, it is possible that you might need a much fuller understanding bilingually of the legislative text. Now, of course, ideally, a fluent Welsh-speaking judge would be required, but in terms of undertaking the function of interpreting, then those four criteria allows the court to fulfill its role sufficiently and adequately.
Judge competent to deal with the Welsh language interpretation so far as it's necessary in the context of that point.
My lord, yes. By necessity, of course, that reflects the fact that there is an independent meaning to the Welsh language, and both languages are on an equal footing. But that form of wording does reflect what the Welsh language believes is required as a minimum in order to treat the two legislative texts on the same footing. The problem and the concern associated with other methods in my submissions is that the role of interpreting is placed in the hands of someone else.
When you gave us your 4 points, you used the word, we need a judge comfortable rather than competent. Which is the word you prefer?
My lady, I think both words are used because a judge has to be competent in order to understand the words and to reach the meaning of the words independently. Being comfortable is something that goes further than the linguistic question in terms of the judicial role of interpreting. It's possible that a judge understands the words but is not comfortable to deal with submissions around the words that is being made. words, but there is a narrow difference between them, which is an important difference. Now, in my submissions, you don't need to overcome any test before that requirement comes up. Of course, it has to be relevant, and if there are no submissions will be made in terms of the Welsh and English text, then the point doesn't arise. But this is not a question of ensuring that the court is tied to understanding the Welsh. That is not what's required. And it is a very minor point to make, even though the administrative court is at the forefront in a number of ways, sitting in Cardiff and transferring cases to Cardiff that deals with public law in Wales, and that the Court of Appeal sits in Cardiff and the Supreme Court have sat in Cardiff. Sitting in Wales and having Welsh judges is different and answers a different question and different problem to the need of having judges that understand the legislation. Now, before I move on to the code, dealing very briefly with a question about the pepper and heart and devolved legislation, I think the only point that the Commission would like to make is this. In my submissions, one must be very careful that looking at pre-legislative text in one language doesn't lead to a higher status to that legislative text. And that follows by the nature of law because of Section 156 of the Government of Wales Act and Section 5 of the Welsh law. But as a practical issue, because legislation is drafted jointly, the fact that matters in the pre-legislative documents come up only in English or only in Welsh doesn't mean that in that text of the legislation that case is dealt with. The text is drafted jointly in parallel, so practically a single language text shouldn't be used to affect the language of that legislation. And then turning to the ground 5, of course, this is
seems from what you're saying that if you have an appellate court, you would need 3 judges who are comfortable in Welsh in such a case, because obviously where you have 3 judges, each must form their own independent view of the meaning of the statute. Another judge sitting in the same court is not obliged to say they agree with the particular judge who speaks Welsh. So, I mean, you're really making this quite idealistic submission that there should be a full bench in such a case that speaks Welsh and filed in the Supreme Court.
my lord, I think my submission in terms of being idealistic is the answer is yes, but I think in reality I accept that the court in its entirety should understand the language. That is what's required, and having one judge would be sufficient. And practically, of course, that was what the High Court has done when they sit as a department, with one judge being able to speak Welsh and another not.
Because there could A, be an appeal to the Supreme Court, or B, questions of legislative So if it's 5 or 7, as it was in Axel, which is a Scottish case with the Welsh Government intervened, you'd be asking for 5 or 7 judges to speak Welsh on your ideal submission.
I think at the core of it, the court itself needs to understand the text, and I fully accept that the interpretation of one judge is not the same as the interpretation of the court necessarily, but at least one judge should be able to reach and get at the meaning and interpretation of the text in Welsh without
judges who speak Welsh, and each of them say, oh no, it means something different. I agree with Mr. Williams, I agree with Mr. Milford. You've still got a problem, which is that judges, the court, is just a word to describe a group of 3 people, or 5 or 7.
Yes, I accept that. But of course, the problem is a familiar one because the courts of appeal don't always agree. And the fact that that doesn't cause a problem in English doesn't necessarily mean that it will lead to a problem in Welsh. I accept, of course, that there is a question mark around how practically the court should deal with that situation, where you have one Welsh-speaking judge reaches one interpretation and a non-Welsh-speaking judge comes to another interpretation. But I think the point of principle that's important is that the court has the ability to interpret the legislation, and that judicial discussion is a judicial discussion.
So, Mr. James, the important thing is what you've just said, and namely that the judge has the ability to interpret the legislation in language concerned. What troubles me about this is that we see in many situations in the European Court, there are texts in French and German and English and Bulgarian, and judges from places where they do not speak fluently those languages interpret them, and they interpret them with a variety of processes, but of course the judges are expert in the process of interpretation and linguistic analysis. And if I may just take an example in this case, I listened very carefully to the submissions made yesterday about the Welsh text of section 50. And I take your point about a situation where there was a broader dispute, where the whole of a statute was in issue, or the whole of a pre-legislative text was in issue, and had to be looked at in Welsh. But in this case, we're looking at a very narrow text, and I felt quite able to undertake a process of statutory interpretation as a trained lawyer in a foreign language foreign to me. Now, I quite understand that to do that I had to hear submission, as one always does, and I heard submissions about the use of words in that language. We heard some this morning. I found them, I may say, very interesting. What I'm asking is whether you're really saying that that process is invalid if you're not comfortable in the foreign language, foreign to you as a judge, and if your expertise as a judge is invalidated. Because whilst I can see that that is possible in an extreme case, no doubt an expert judge who has the expertise of interpretation would recognize when that was the case. And my feeling is that statute is being interpreted that is alleged to say different things in the two languages, where a judge who doesn't speak the second language fluently, or maybe speaks the second language to a moderate level but not fluently, is perfectly capable of doing it. And it just seems to me that the thing is not binary, that there will be many cases where it is possible to interpret legislation in a language foreign to the judge, whilst accepting that there may be cases where it is difficult to do so.
My lord, it's a very fine margin, but it is an important one. And I think what that boundary states is this. On one hand, the judicial ability to understand the language and understand the text with the support of submissions, of course, that is, submissions to persuade you as a court. But on the other hand, a situation where the interpretation is received from the submissions that are made. And in the second case, the Welsh meaning doesn't come independently from the Welsh words, but rather come from the submissions that are being made. And because the two languages are on an equal footing, therefore the words themselves need to be understood, and then it is a case of persuading through submissions, rather than the submissions themselves creating a basis of understanding or interpretation or understanding.
Part company with you at the moment on this, speaking only for myself, is that in this case we see as an example that the word in Welsh for education is the word in Welsh for education. Nobody is making a submission that it doesn't mean exactly education. And so you have to identify what you're arguing about before you can decide whether the process of interpretation can be conducted by somebody who is not comfortable in Welsh. It cannot be a binary submission. In one case, to take a case outside this particular one, there might be an issue as to whether a particular word in Welsh had the same meaning as a particular word used in the English statute. And you would have to have submissions maybe from, maybe evidence from linguists, from historical writers, as to look at that word in its context, where it had been used. As when we look at the dictionaries, we see that dictionaries refer to the usage of words in historical documents, and that informs the process. Now, that can be done without being comfortable in the entire language if it's simply the meaning of one word. Conversely, I find it quite difficult to see the situation, but there could be, and I accept, there could be situations where the thrust of the expression would only be explicable to a fluent speaker of that language. I can understand that. But what I'm asking whether you accept is that there will be many cases that are far less binary than that, where the particular issue is intelligible to a non-fluent speaker and perfectly properly constructed by a person who has heard submissions on all the relevant matters that go to the process of interpretation.
I think the only way to ensure that the text in both languages are treated equally, if the method can be used in both languages. So the corresponding situation is a judge that can speak Welsh and advocates that make submissions through the medium of Welsh, dealing with a statutory test and a text using a dictionary to reach the meaning of the word in Welsh, rather than the court looking at the statutory English text. And in my submissions, that is not a situation that the court would allow with the English text. So therefore, by necessity, it would not be a situation that would place or would hold the Welsh on an equal footing to the English. My lord, I agree that there are different extents of the need to understand, and in response to Lord Justice Lewis, I used the 4 criteria that I did, but an integral part of those points is that the Welsh itself is understood, and not the meaning of the Welsh understood in any other way, such as expert evidence or a dictionary.
If I am told that the word education in Welsh means education, then I do understand the Welsh precisely, don't I?
My lord, I must agree that it would be possible for a non-Welsh speaking judge to understand Welsh words, but the question of interpreting legislation in Welsh is different.
Sometimes it is, and sometimes it isn't, which is why I'm trying to get to the bottom of your submission. In some cases, the interpretation of legislation is simply to interpret a word. In other cases, it's to interpret syntax, and that's the argument here, as we know. But there are a whole variety of exercises in statutory interpretation, and all I'm really putting to you is that it depends on what type of statutory interpretation is in issue, whether it can be done competently by a non-fluent speaker. I mean, we have seen here that Lord Justice Lewis has an understanding of Welsh and is able to speak some Welsh. He doesn't claim to be totally fluent in Welsh.
I don't speak Welsh.
Well, he does speak some because he's done so in court. And the point is that what I'm trying to get to with you, Mr. James, is whether you accept that this question is not a binary one, and that there is a scale depending on the issue before the court of what is required fairly to interpret the Welsh text. I think everybody accepts your primary point, which is that both texts have equal status and must be accorded equality and have to be looked at where there is a dispute that they don't mean the same thing. So I'm not quibbling with you about that, but even accepting that, what I'm putting to you is that there must be a gradation in what you need fairly, justly and properly to construe a statute written in 2 languages of equal status.
And my lord, in my submissions, I think the form of words that whether a judge is comfortable and a judge who's able to understand the statutory text before them would allow for that wide scope of cases, and not so a judge who can the whole case through the medium of Welsh, always on a formal list of Welsh-speaking judges, but someone who is comfortable. And in that case, of course, if it's just one word, which is education, this, if that is the disagreement between the parties, then I think the needs and requirements around the Welsh or the language is much less than if it were a whole statutory system.
Thank you, that's helpful.
I'll deal very briefly with ground 5. Now, the submissions of the Welsh Language Commissioner means that the factual decisions of the High Court were correct. You were taken yesterday to page 221 in the supplementary bundle, and in response to questions yesterday and this morning to Lord Justice Lewis, the numbers and transport were discussed, and what the final paragraph on page 221 says is that rather than just 70% of those in Ysgol Gymraeg Bonsiwn Norton that used school transport at the time, that would increase to 100%. So by necessity, therefore, 100% of those pupils would live over 1.5 miles away from school. And please correct me if I'm wrong, but there's no evidence at all before the court that the council, as I understand it, will provide transport for school hours and extracurricular hours. And what that paragraph says in the final sentence, it's common for learners accessing Welsh medium education to be transported to and from school, and access to before and after school activities can be a challenge in these cases. By necessity, therefore, as a result of the changes in Ysgol Gymraeg Bonsiwn Norton, than 70% using school transport, finding it difficult then to participate in extracurricular activities, then in fact the whole school would have to use school transport, and therefore to come across the same problems. So it's these questions that the Commissioner emphasises. Not only choosing a new larger school with more surplus places, but changes that affect the daily issues that people want to receive Welsh medium education a lot.
We have your submission. I see what you say about it's 100%, and there are 30% who might be deterred. I suppose we don't have the policy on school transport for after-school activities, but in fairness, Mr. Milford took us to page 212, and the penultimate paragraph, and you may say it's not enough, but last paragraph, the last sentence, the English sentence, he does not consider that distance to school would be a barrier to any child who wishes to participate in the pre- and after-school provision, and whether they're going to provide school education or not. They're the elected council, we are just judges, and they are saying in this document, we considered it, and we think it will be all right. And unless it's irrational in public law terms, we can't decide what, going up and down the Rhondda Valley and changing the Pontypridd bus station, whether that's enough.
Except that the factual matter that I wanted to highlight was under 221, page 221 says, is that there will be more problems and that it will be more difficult rather than being easier, as the council suggested yesterday. Now, the question of accessibility and availability and of Welsh medium education is something that we need to consider by looking at a number of different elements. Choosing a site was one particular issue that was raised before the High Court, and that was accepted by the High Court. But again, emphasising the fact that this is not a mathematical exercise. This is not a case of comparing numbers. but rather looking at the impact. And at the basis of all that, the Welsh Language Commissioner's submission is that only one consultation document was published for all the changes, and that is the grounds of the report and outcome of the decision of the Commissioner on that one consultation document, which is applicable to all the changes before the court.
This is not a challenge based on an alleged failure to consult. This is a different challenge that the decision to implement under a different section, 53 I think, whatever it was, failed to have regard to the impact on Welsh secondary education of closing Rhondda. So how does the consultation document, which isn't before this court, affect the question of looking at the things that might impact on Welsh secondary education? Has the elected council considered them or not?
Well, as I understand the case of the claimant, because, and they are different, but because the standards have been breached, it therefore means that the necessary information was not before the council to reach a decision. Now, of course, I accept that that is not a matter for the Commissioner to see if there's a breach of public law, rather than any duties around wider consultation in this case. That deals with the relevant question around evidence.
Because we've got two written statements, we've got the community assessment, we've got the Welsh language assessment, we've got those other strategy documents, and we're looking at a different question. You're looking at consultation. Were the people of Rhondda Cynon Taf properly informed? That isn't what they're complaining about. They don't say they weren't properly informed. They say when you took the final decision, you didn't think about the consequences. So it's the link between the two.
I fully accept that. The link is this: without having a consultation process that deals with the Welsh language as it should, and therefore does what is required by the Welsh language standards, that means that something special is needed to show that the consultation process has dealt with these issues. To put it simply, if they don't get it on the consultation document, then where does the information that undermines the consultation, where does it come from? My Lord, that is what I have to say about the code on ground 5. You have my submissions around the principle and the use of the Welsh language. So unless you have any further questions.
You're being supplied with a veritable array of yellow posters. Well, perhaps I can start before looking at the pages and then carry on. 4 brief points on the claimant's submissions first, and then one point that my Lord Justice Lewis raised with me yesterday, just a factual point. The first is my learned friend's point on Benyon this morning, in answer to the issue, why is the phrase "ymwneud" there at all? And you were taken to section 21.2 of Benyon, a passage about deliberate tautology, or if words are unnecessary for other reasons, by reference to what Lord Hoffman said in Walker against Centaur Close, that being, it's not unusual for Parliament to say expressly what the courts would have inferred anyway. And I just make the brief point that this isn't a case of the Welsh Assembly saying expressly what the courts would have inferred anyway. On the claimant's case, it's the opposite. It's the case of the Assembly expressly precisely what my learned friend says the court should not infer. And in that case, there are obvious reasons, we say, why an argument against redundancy should carry very considerable weight. You can't stop before the phrase unenig and say, let's disregard it because it's tautologous, if it changes the meaning. The second point is what is said against me on purpose by reference to section 71 of the Act and the Welsh Minister's funding responsibilities. And this picks up on a point that my Lord Justice Lewis raised yesterday, because it said, well, there may be a reason why section 71 is narrower than section 50, because under section 71, it's logical that the Welsh Ministers can only make proposals concerning sixth form education because that's their funding responsibility, but if proposers could get rid of sixth forms as part of wider proposals, and the Welsh Ministers weren't able to stop that, their functions in respect of sixth form education could be undermined. I understood that that was the suggestion that was being put against me on purpose. I think my response is that first of all, we say there's no evidence that that sort of subtle distinction of purpose from the pre-legislative material. There's nothing in the contextual material to suggest that thought was given to the distinction between the ambit of the two sections for this reason. But more than that, we say it's not a real policy problem. The Welsh Government has all the powers it needs to intervene without any policy reason for giving section 50 a wider ambit than section 71, because if a local authority closed a school including a sixth form, it's always open to the Welsh Government in those circumstances to say, you local authority should create a sixth form, or you should add a sixth form to an existing school. We think there should be a sixth form in this area. Here is our proposal under section 71. And indeed, if what the local authority were to do was to close the school with a sixth form and reopen a new school without a sixth form, it would always be open to the Welsh Government to say under section 71 as a sixth form. We think there should be a sixth form in this area. So we say there's no policy gap, and you don't need to have the blunderbuss of being able to stop a complete proposal for the whole school, which happens to include a sixth form, when you've got the rapier of being able to add the proposal that only involves the sixth form under section 71. My third point on my learned friend's response this morning concerns ground 3. In my submission, my learned friend has not adequately explained why 1.9 of the code is engaged by proposal 4 at all. He accepts now that if proposal 4 been on its own, it would not have fallen within paragraph 1.9 of the code, but he says that because it's linked to proposals 1 to 3, it does fall within it. And my response to that is it's not what the code says. The code addresses proposals, and each proposal here, as my Lord Justice Lewis indicated, is legally separate. It's published by a separate statutory notice, albeit that they are, as we all accept, part of a wider school reorganisation. And my learned friend has not explained why the code should be read differently just because more than one proposal comes forward at the same time. So that's what we say on ground 3, and it's quite apart from our answer on the facts on ground 5, which I don't think I need to take.
Two minor questions about that. One, you would say that's supported by the fact that 3 of the proposals are going ahead, even though Cardinal Newman's got to go off to the Welsh Ministers anyway. But what you say to Mr. Williams' point that you can't have proposal 4 unless you have proposal 3, because you've got to put the English Hill or Kelly children somewhere. Well, English speaking, that is. That they're Welsh like all are, but they've got to go somewhere else. And they're going to 4 at the moment. So if you don't do 4, where are they going?
Well, I mean, I think the answer is it's not. Well, the answer is you might have to have a slightly different form of proposal. I mean, you'd have to decide in a slightly different way where they should go. So in that sense, I accept that the.
I see. So you'd have closed it, but you wouldn't have put the English medium children somewhere else under 3. And if you haven't got proposal 4 because something's happened to it, then you're stuck with finding somewhere for the children to go to.
You have to find somewhere for the children to go. that's going to depend upon what availability is in other English medium schools in the area.
Or even creating an English medium class in the Welsh primary schools, as they do at Helen again anyway. Okay, so that's what you say, is that's consequences, is your submission, not legal definition.
Yes. And the fourth point concerns ground 4, where my learned friend says that 1.4 of the code was dealt with, albeit in the context of paragraph 1.9, because 1.9 was said to be the claimant's principal ground. And I say 1.9 wasn't the principal ground, it was the only ground, the only claim. And my learned friend says, well, if there was a suspicion of procedural irregularity here, it should have been raised with the judge at the time. And the answer to that is, we didn't know that 1.4 of the code was an issue at all as part of the claim until we got the written reasons for refusing permission to appeal. So it wasn't possible to raise with the judge. As far as the facts are concerned, I rely upon everything I said yesterday, and I don't think I need to add to the submissions that I made on those. I don't propose to reply to what my learned friend, Mr. James, has said. So that is all I'm One tiny point I perhaps should have raised, which is my Lord Justice Lewis was asking yesterday, what is a middle school?
Oh, yes.
And a middle school is defined in Section 5 of the Education Act 1996, the school which has been established to provide full-time education to requirements of pupils who have A, attained a specified age below 10 years and 6 months, B, are under a specified age above 12 years. So it's basically primary plus secondary, but it could be a number of different ages within that. It could be 3 to 19, or it could be 8 to 13.
Thank you very much, Mr. Good, well, we will take time to consider our decision and our judgments, and we'll hand them down in the usual way, which will certainly be electronic, and give you an opportunity to suggest typographical corrections of substance. It would be helpful if you were able to agree any consequential orders that need to be made as a result of our judgments, including costs. If you're not able to agree them, then we will deal with those matters in writing, and you should exchange submissions as efficiently as you can. If you need directions as to how to do that, then we will give those directions. But it only remains for me to thank all counsel and solicitors who are not in court, but no doubt listening to the live stream, for their very efficient preparation of the case.